Hello, this is our lecture 6 in CJPS 379. It's February 8, and I am going to review some of the materials from the earlier chapters of the text by Neubauer. So focus on chapters 1 and 2 for this lecture. And I'm also going to discuss briefly the ethics complaint concerning Steve Hurley that I've just posted, and how it highlights the role of the defense attorney as well as the role of the prosecutor. Let's kick off by talking about the exam, what I'm expecting for that exam, and some of the earlier lecture topics, text topics, cases up close, videos that we have discussed, assignments, so that you're ready for this exam. And the exam is going to be short answer as well as essay, probably one essay question. It's going to ask you to draw out the issues, short answers about some of the matters we've covered, just to make sure that you have read the materials. So let's go right to chapter 1 and what we set up there for you to understand the judicial process. If I were you in chapter 1, I would focus on first of all, the models of the system. There were two theories, you'll recall, and one was that of an interdependent system. The other was that of a fragmented system. Now, in this lecture, I'm not going to go into detail about those. We have talked about them before, but keep in mind it's very interesting that the system has to deal with controversy. It's an adversarial system. There's also gamesmanship that goes on, and all at the same time the system wants to kind of spew out year after year case law that comports with the model of common law, so that just results are reached based on prior cases, that we adhere as much as possible to that concept stare decisis, which means following prior case law and established precedent. How does this system work, though, when it's so adversarial? It has such different players and such unpredictable witnesses and personalities, forces such as the media, for example. Well, there were those two theories that some research says that it's interdependent, closely working with everything, but there's another theory that it's fragmented. There might be a question that arises out of that, because I've had cases, and we've studied cases in this class, that have to do with actors acting outside of their bounds, or the media overhyping a case, or perhaps a defense attorney getting more out of a case than he should have, maybe because the prosecutor didn't prepare it, i.e. Casey Anthony. So how are we to view it? Is it just interdependent? Is it just fragmented? I might have a question for you about the cooperation between players in the system. What happens when the media interjects itself in a situation and misportrays a case? The media, I think, is part of this system. Often they work for the state, in effect, because they are reporting the state's cases in a favorable light. But what happens when the defense attorney is sitting at his desk or her desk and gets a phone call from the media? Is it a fragmented system? Should the defense attorney just ignore that phone call? Or are there things that help these parties work together? There was once a time when I viewed the media with huge suspicion. I think a lot of us still do. But then I had a case where I was on the evening news, and the media, as I had planned it, spun my case in the direction that I was seeking it to be spun, only based on the facts, of course. But of course I had just won a hearing, so the media had a reporter there. I was on the evening news. Until that day, I really thought that the media was kind of adversarial to the defense bar, the defense attorneys in the community. But when you have the right case, the media can be an ally, can be a voice box for your client. When, say, as in a case like the Duke lacrosse players, the media has at first been adversarial, there can be a turning point, which players in the judicial system should always be aware of, that some party can be an ally as well. So is it fragmented? Is it interdependent? Does the prosecutor always work against the defense? Does the police always help the prosecutor? Are there cases where the police and the prosecution don't get along? Are there cases where the police and the defense sometimes are allies? There might be a question about that, and I'll just ask you to make sure you are aware of the segment in Chapter 1 where we talked about how the system, or where you read how the system can be extremely fragmented. But there is probably one way of looking at it that takes into account both the fragmentation and the interdependence. And that's been my experience, to see the system working not perfectly. It has human players. It has people who are trying to get away with fraud sometimes. It has people that are trying to do too much because they think that their side is the only just side. So the system working in a way that is at odds sometimes, but also collaboratively, I think both of those things are happening at the same time. And that's the kind of maze or milieu that a player in the system has to navigate to be successful, because otherwise you're constantly bumping into the wall, especially as a defense attorney, but sometimes as a prosecutor trying to deal with police departments. You may constantly be bumping into a wall of silence, but there are ways to navigate that involve both fragmentation and interdependence. So keep that in mind in Chapter 1. We also talked about finding the courthouse. We talked about how the origination of a case in a particular jurisdiction can have massive consequences. So be aware of the rules that guide where a case originates. The jurisdiction, for example, be aware of those rules, because there might be a question that comes from that. I talked about in the beginning of the case, or the beginning of this course, that there were 3 different elements that would constantly be coming up in our course, and that is how the courts and the system are based on a model of controversy and dispute. We call that the adversarial system. That there's a sporting element to it that makes the adversarial system work. A lot of people don't want to admit it, and it does tend to go back to the medieval period. But there's still this element in which there's a game going on. So a question might arise on the exam out of one of those theories. There's also the common law, how the common law developed. Those are the 3 themes that we started off this course with. So there's going to be a question that comes out of that. Those are in both the text and my videos. Engaging with personnel in the courthouse is a very important element of the way it works in the real world. So keep in mind that I continually talked about and reflected back on the idea that a party does not operate in isolation, that the defense attorney, to be effective, always has to consider what the prosecution is going to do. So some of the most effective defense attorneys used to be prosecutors. On the flip side, and this is hard, but a really good prosecutor keeps an even keeled temperament, okay? That is, they don't always just think they're right, that their cause is the white knight of justice. The prosecutors that I've seen do that are usually the young ones, inexperienced, or the ones that never have gotten it, never have had a case where they had a dilemma, and they've always thought they were right. Very difficult to deal with. But a more even-keeled temperament would be a prosecutor who takes a look at the other side, the defense, and sees what the defense might be trying to accomplish, even though that seems perhaps to be, to the state, a little bit too accommodating of another party. It actually helps the prosecutor be more effective in their cases, because when they come to court, they'll know what the defense attorney is trying to accomplish and they'll be ready for it. So having mutual respect for personnel in the courthouse, everything from a bailiff to a judge to a court secretary to an assistant in the prosecutor's office, that often helps the wheels of justice move more effectively. Having full understanding from another party's position. That model of the court system, again, it harkens back to the interdependent system I was talking about. That's an important element. There might be an exam question that comes out of that based on our cases that we've been talking about on the text. One example, for example, is the Duke lacrosse players case. This prosecutor, from the beginning, in my opinion, had a temperamental problem. Not that he had a bad mood, but his you could say judicial or legal temperament when it came to how to handle cases was a little bit, I'd say a little bit dysfunctional, if not sick, actually, because I think he, first of all, there's established data that he hated lacrosse players, going back a long way, that he was sort of a lone wolf, did not have a good record of working well with the defense bar. In fact, seemed to lord it over the defense bar. Anybody who challenged him was a problem. He had not been challenged. That particular jurisdiction was sort of a closed jurisdiction where you either did it the way the prosecutor said, took their plea proposal, or it was their way, or it was the highway, until the Duke lacrosse players case came to this prosecutor's attention. So that might explain why this prosecutor, somewhat blindly, I don't think intentionally, somewhat blindly stumbled into a situation where his usual modus operandi of prosecuting a case was not going to work, either because he was up against a very powerful group of individuals. I think, I don't know if you students know this, but the Duke lacrosse players' parents were very highly placed, powerful people. I'm not going to use the word privilege because that's just a pejorative to think about it, but one of them was an investment banker on Wall Street. One of them was a Washington lobbyist. One was an attorney in a very large firm. This was a party that you had to have mutual respect for. Not that you had to coddle to them, but if you didn't understand where they were coming from, everything from their history of racism, because I think that's been established, their backgrounds, their education level, why they had the party, their parents, their social networks, it would be very easy to think, well, these are just students, just dumb, white, overprivileged lacrosse players. I hate lacrosse players. Let's see what they come up with. I've always gotten my way in this jurisdiction. That's a dysfunctional way of looking at things. An exam question might arise from that kind of scenario, maybe even an essay question, because I found the most ineffective players in the judicial system were always those players that just didn't see the other side, just didn't have mutual respect. So even, I don't think mutual respect is used in the text, but in the first couple of chapters it talks a lot about interdependence, those theories. Be very aware of those theories, because I think that's what went wrong in the Duke lacrosse players case. It was more of a systemic problem, I think, than just the individual prosecutor. I think it was a systemic problem because that particular district in Durham was used to always getting its way as prosecution. And no, my opinion as a defense attorney, that the Duke lacrosse players' attorneys, well, they might have won the case, right? I think any good attorney would have won that case, but they weren't out in front as effectively as they should have been in the early goings of the case. They were somewhat waiting to see what the other side was going to do. They were kind of approaching the prosecutor with this theory of innocence. I never did that unless I knew the prosecutor to be a collaborative prosecutor. This was a prosecutor known to be not collaborative. There was another way to approach the case, and that is to get out in front in the media, to talk about facts that were undisputed, to perhaps send out an investigator to find out what the other side was saying. I mean, that's aggressive defense. This complainant in the case, Miss Mangum, if that's how you pronounce her name, turned out to be a very bad witness. She's currently under investigation and charged with murder of her boyfriend. The attorneys for the lacrosse players didn't know that at the time, but there were some clues in the case early on that this witness was a wild card and needed to be interviewed by an independent investigation. Well, we say independent, but who's to say that the defense cannot bring an investigator to go out and gather facts? The defense cannot bring a private eye, do some monitoring, do some unconventional evidence collecting. Everything from sending out a legal assistant to go get police reports in a surreptitious way. I've done that before in cases. You have to have a very good connection with the office that dispenses the police reports. Like there was one case where we sent out a legal assistant to schmooze with a secretary who she knew at a police department, and just to simply offhand kind of ask for some police reports that weren't allowed to be disclosed yet, just by the prosecutor, not under rules. And we managed to get police reports ahead of the prosecutor, even knowing that we had them. We would do things like that to get a leg up on the case. I don't think the Duke lacrosse players' attorneys ever did that, which now segues to the portion of this class where we're going to talk about not just the exam, those first two chapters, but the case of Steve Hurley being charged with an ethics violation. Take a look at the posting that I've made of that final decision. I think it's by the Wisconsin Supreme Court, in which the dismissal of the ethics complaint is upheld. So that's the result in the case. A very interesting case. I practiced in the same jurisdiction as Steve Hurley. We had a couple of encounters in the courthouse that I recall. Mutual respect, a very good attorney. I would say they're one of the best that I'm ever going to meet in my practice. Right up there with the attorneys that represented O.J. Simpson, F. Lee Bailey, and he was the kind of attorney, to segue from our previous discussion, that would engage in these aggressive, proactive activities of either investigating, monitoring, sending out feelers, not just trying to cooperate or go discuss matters with the prosecutor, but going his own way to try to gather evidence in the defense of a case. In the particular case that you'll read, take a look at that. From the public's perspective, it looks like Attorney Hurley has done something really underhanded. What he did in that case was his client was accused of possessing and introducing to a young person child pornography, videos, images, and the theory of the defense was that it was actually the alleged complainant, a 15-year-old boy, who had been the one that was collecting the child pornography, and that instead of his client, Mr. Sussman, introducing it to the 15-year-old, it was actually either a mutual encounter because maybe the defendant in that case, I think he was much older than the 15-year-old, had sort of an inappropriate relationship with this individual, but that the individual was also engaging in the disclosure of this child pornography. That the theory of the defense was, Mr. Sussman was not being charged with sexual assault or intimidating a minor or anything like that, but that he was being charged simply with possession, and that he would introduce this material to this minor. And early on, Mr. Hurley had a suspicion, and a pretty good one, that the minor was engaging in mutual conduct with the older individual, Mr. Sussman, and that he was the one who had collected and introduced the child pornography into the relationship. A very small distinction. And from the public's perspective, one might say, who cares? But the individual in that case was being charged with simple possession and distribution of the child pornography. There was no evidence about whether or not the victim in that case was victimized by the child pornography or somehow was groomed by Mr. Sussman, and perhaps would have gotten that far, but that's not where the case was. So Mr. Hurley, the attorney for Mr. Sussman, is not going to get this evidence that the minor is disclosing, collecting, distributing the information instead of Mr. Sussman, is not going to get that information from the prosecutor. You can kind of imagine why. In fact, as a chess player, as a player in the system engaged in a sporting kind of activity to try to bust the case open, to raise reasonable doubt, you are probably not very intelligent if you disclose your theory that early in the case to the prosecutor. Oh, we think that this is actually what was happening. The prosecutor is then going to shore that all up with his own witness and make sure that the witness knows how to answer questions in that regard. No, instead, Mr. Hurley is going to do something else. He's going to do what a zealous defense attorney would do. He's going to try to collect evidence in that ethics case. It's going to be detailed. He's going to try to collect evidence in a way that the police collect evidence, using deception, deceit, actually a kind of sting procedure. Okay, we've seen in the movies these investigative techniques where the police are looking for somebody, and they haven't been able to find that person, or they haven't been able to get the person to admit their guilt or turn over information that is relevant to their guilt. They'll have a public activity, like I think the one that I'd seen on TV was it's not a sting actually, but it's a falsely set up activity in which something is being given away for free. The public's invited, or certain people get mailings that they're invited to this because they're somehow engaged in work or activity that's related to what's being given away for free. That's what Steve Hurley did in this case. He actually prepared an investigator and instructed him to pretend that he was part of a computer company or a software company, I can't remember exactly what it was, that was giving away or that was running tests on computers and collecting data just for survey purposes, and was giving away computers in exchange for being able to study the use of the computer by an individual. And so there would be like a computer exchange. Mr. Hurley sent out this investigator, and the person the target was the complaining victim in the case, in the Sussman case, sent out this investigator to exchange the computers with this individual. The individual believed in the ruse and gave the computer to the investigator in exchange for a free laptop, was allowed to erase whatever he wanted to erase from it. His parent was also present. They believed the ruse. It was cleverly set up. And if I get a few facts wrong, just make sure that you double check it with the ethics complaint ruling that I posted. But essentially, the investigator posed as the representative for a company that was doing some kind of research and wanted to study the data from the computer, the data that the individual was willing to release. Somewhat naively, the family and the individual, clearly the mother not realizing that there was child pornography on the computer, released this personal laptop that I think Mr. Sussman did not have any access to, it was not his computer, would not have been able to download child pornography. And lo and behold, the investigation finds child pornography on the 15-year-old minor's computer. So a very interesting minor who's not just a pure victim, as we would imagine if we were just looking at the complaint by the prosecution. Suddenly the case becomes completely different. You can imagine what the prosecutor thinks. Number one, all of a sudden I've got a case where this could be introduced in trial because any material, evidence, videos, images that tend to exculpate, show to be innocent, the defendant, is admissible no matter how ridiculous it might be. And in a case that the accused is being charged with possession of child pornography, the fact that the minor alleged victim may have introduced it into the relationship is extremely relevant. I can't think of a more relevant piece of evidence, even though it seems to be titillating and bizarre that we would bring that into a trial. But in a judicial process, it's extremely relevant that another person was actually the instigator of an activity between two individuals. So that's going to come in. You can see the prosecutor thinking, oh my God, I'm going to have to try a case where this is the matter, that my victim has done this. And even though the accused is being charged with a very important and egregious bad offense, the trial might end up being about the victim instead of the accused. And if that's what the state of the facts were, let it be, because that's exactly where the judicial process should be inquiring. It is the state's obligation to prove the matter of the defendant's guilt, the accused's guilt, beyond a reasonable doubt. And if there is a doubt as to who injected the materials into the relationship, well, the jury should explore that. Suffice it to say, Mr. Hurley would never have gotten this information on behalf of Mr. Sussman through any meetings with the prosecutor. That goes without saying. Once he did get the information, there was an issue as to the propriety of how he got the information. That became the basis of an ethics complaint. The prosecutor kind of the opposite of the Duke lacrosse player's case. The prosecutor here appears to be the knight in shining armor, and the defense has engaged in this slimy, underhanded technique to try to get material on behalf of its clients, even though the material is true. There's no illegal allegations about the nature of the evidence. It wasn't a plant or anything. It's a sort of reverse defense sting operation setup, or I don't know what the technical term of it is, but it's a fraudulent ruse that's meant to get the witness to disclose evidence. The DA, the main DA, I've met the individual. He's now an appellate judge in Madison, Wisconsin. Files an ethics complaint. He's a reasonable guy. I've met the guy. He's not some kook. Very studied, reasonable. Became a judge. He thought that the technique was illegal because it involved fraud, and there's an ethical rule that says the defense attorney shall not engage in fraudulent conduct, or that an attorney shall not engage in fraudulent conduct. Of course, the police do this all the time, as we know. So I'm not going to talk about what the results of that ethics investigation were. I'd like you to take a look at that and read that thoroughly, and over the weekend we'll have a forum about it. It's a very interesting case. In my opinion, it's an example of extremely zealous representation on the part of the defense bar. Also, it's a great way to segue to our next topic, which is going to be disclosure of evidence, the discovery process. It's a pretty straightforward chapter 12. It's the last chapter you'll need to know for your exam. But the sting that Hurley undertakes is very important to understand, because there are many situations in cases like that, especially high-profile cases, where the defense has no other way of getting the evidence, because the defense don't have a police force. The defense do not have the victim on their side. They can't approach the victim and just ask for it, because it's just that kind of case where there's this controversy that's highly disputatious, highly titillating. The victim claims to be victimized by this older man. There's no way the defense is going to be able to be in some kind of collaborative relationship with the victim witness. But there's another way, and many attorneys would not have done this, and it's unfortunate, but I think the role of the defense attorney is exactly what Mr. Hurley did in that case. So take a look at that and what the outcome of the ethics complaint was, and we'll then use that case to discuss the disclosure and discovery chapter 12. Thanks.